to receive a link to download a copy of this white paper, which will officially be released publicly tomorrow. So you will be able to read more detail about some of the things that we're going to be talking about today. And also, you will have a chance during this webinar to ask some questions. If you do have questions, you may put them in the chat, and I'll be monitoring that. We'll be able to answer them. Certainly by the end, we will open to questions formally, but if you do have questions while we're speaking, please feel free to just enter them, and we'll try to make sure we get to as many questions as possible today. So with me on this webinar is Karen Handorf. She is Senior Counsel at Berger Montague and a member of the firm's Employee Benefits and ERISA Practice Group. We have Julie Selznick. She is also, she's a Senior Counsel at Berger Montague and a member of this firm's Employee Benefits and ERISA Practice Group, both of whom are truly leading attorneys in the area of ERISA. So this is, we are really privileged and honored that you could join us, and that you have you've been so forthcoming in participating with Leapfrog in developing this white paper that I think is going to be of enormous value to employers. So thank you for being part of this. And then of course is Jamie Greenleaf, as I said, who has advised Leapfrog. She is the co-founder of Fiduciary in a Box, which we'll hear. I think you can tell us a little bit about what that is. I love the title. And she spent her entire career acting in a fiduciary capacity, helping employers design and implement retirement programs. But she's an expert in health benefits as well. So we are also just delighted to have you join us. And thank you, Jamie. You've been a leader in alerting Leapfrog and all of our constituents really to the importance of the CAA. And really were the one who brought to us this, this very significant change in federal law that employers themselves have not been as well informed about by their own consultants and advisors as we would hope. So now, luckily, thanks to, I think, your very determined effort, you have made sure that employers know the importance of this and that they are at some risk if they don't take some steps to do what's needed in this law. So I appreciate so much your vision and your fortitude and your determination, and of course your expertise. So thank you for joining us. So let me start with Jamie. You're going to give us a little overview of the Consolidated Appropriations Act, the CAA. It's a lot of syllables, but why don't you give us that brief overview, and then we'll turn it to our attorneys.
Sure. Thanks, Leah, for having me. And thanks to Leapfrog for keeping this center of attention for employers. I think there's a huge opportunity here for employers to really enhance benefits and control costs and really get quality care to employees. So kudos to you guys for keeping it front and center. So just to level set, and many of you probably are already aware with, but ERISA covers both retirement programs as well as the health and welfare plans. However, there's been some difficulties in providing a fiduciary process around the healthcare plans because there's been limited information that employers have had access to. The CAA of 2021 was actually signed into to legislation back in 2020 by Trump on the 27th of December. And there were 4 pieces that came out of that CAA. It was very long. Most of it had to do with COVID relief, but there were 4 pieces that came out around the healthcare piece. And the first one was the removal of gag clauses from covered service providers' contracts. What's interesting about this is that this now gives employers the ability to have access to their information around quality as well as cost. So really important that they opened this up, and now we can actually start to do a fiduciary process on our health benefit. The second piece was that we needed to understand who and how we were paying our covered service providers. So disclosure of direct and indirect compensation from all covered service providers, not just a few, but all of your covered service providers. So now you actually understand how those people that are working with you are getting compensated, both direct and indirect, which is with a little bit of an eye-opener for most employers. The other 2 pieces that were important that came out of this had to do with reporting requirements on pharmacy and prescription drugs. And that's something that many have been working with and struggling with, but it really is to provide information to the government around kind of what's going on in the RX world. And we've seen a lot of talk about that on the Hill as well. And the last was the mental health parity report. And this is something that in 2008, we talked about mental health parity, but this really expands it to provide employers with the ability to receive information and to quantify kind of the difference between what they're providing on one benefit versus the mental health benefit. So really excited to add this transparency to employers, but now that means that they actually have to start to have a fiduciary process around their decisions. And I know Karen's going to get into that. So.
Yes, it's always been somewhat surprising to me that some people think that the CAA suddenly made those who manage healthcare plans subject to ERISA. ERISA has regulated healthcare plans since its beginning in 1974. It was just a simpler world then, where you had insurance, or people went to their doctor and they submitted a claim and it got paid. But now with managed care and network plans, it is becoming much more complex. And those that are in charge of plans are really in charge of what doctors or employees are going to see and how much, at what cost they're seeing those doctors. And so that's pretty important. And this is a big responsibility, and ERISA requires you to do it right, or at least have a procedure in place that's designed to get you to do it right. People that are running healthcare plans are fiduciaries of those healthcare plans. And that means they are subject to ERISA's fiduciary responsibilities, which one court described as the highest known to the law. That means that if you are a fiduciary, you have a duty to act prudently and loyally and exclusively for the purpose of providing benefits to your participants and beneficiaries and deferring the reasonable cost of the plan. You must follow the plan terms unless they violate ERISA, and you cannot engage in what ERISA calls prohibited transactions. Those are transactions with parties and interest, which ERISA defines and includes service providers like TPAs to healthcare plans. So of course you need service providers. So ERISA has an exemption that says, yes, you can engage in a transaction with a service provider, but you can only do it, it's only not prohibited if the fees are reasonable and the services are necessary for the operation of the plan. That existed before the CAA. All the CAA did was describe more clearly other requirements that those disclosures must meet in order for you to meet the prohibited transaction provision. And of course, there are excise taxes that are involved if you engage in a prohibited transaction, as well as enforcement against you. So what does this mean in practical terms? The Department of Labor, who enforces these laws, issued guidance more than 20 years ago and said that one of the foremost requirements is that a fiduciary engage in a reasonable process for choosing service providers. And it said, a plan fiduciary's failure to take quality of services into account in the selection process will constitute a breach of the fiduciary duty under ERISA. So long ago, the Department of Labor said quality is a concern. So what must you do when you're engaging a service provider like a TPA? It's all about process, not just all about process. You obviously have to have a process in place that's designed to give you a prudent result. But that process should elicit the qualifications of the provider, the quality of services offered, and the reasonableness of the fees charged in light of the services provided. Process is key. You must study the options and have a process in place to make decisions about these particular elements. You do not have to be an expert, but if you aren't, you need to hire an expert to assist you if that's necessary. But the expert is not a whitewash. You need to understand what the expert is telling you and you have to make your own decisions. That isn't the end of the story, though. You don't just hire a service provider and then just let it go. You can't be on automatic pilot. You can't think that your service provider is your friend and that they're doing everything right for you. You must engage also in a process to evaluate the performance and cost of your healthcare options on an ongoing basis. That means that you must obtain information about the fees that you are paying your service provider. You must assure that the service provider is following the plan documents. You must assure the quality of services offered are being maintained, and you must evaluate conflicts of interest in terms of how your service provider is engaged in the activity with respect to your plan. So fortunately, the CAA gives you new tools. As Jamie said, the gag clause prohibition should make it easier to get plan claims data, which should provide a wealth of information about all of those points that you need to look at. And the fee disclosure requirements should give you a clear picture of your service provider's fees and whether they are reasonable. But determining whether they are reasonable, of course, depends a little bit on the quality of the services provided. Everybody recognizes you're probably not dealing on a level playing field with your TPA. Our experience is that TPAs don't want to give you any of this information. They say there are no gag clauses in their contracts. But when you try to get the information, they either limit it or they put a lot of limitations on you, what you can do with that information once you get it through non-disclosure agreements. So this requires employers and fiduciaries to be very strong. And when they're negotiating those contracts, to make sure that they get what they need in order to do what you need to do. You're not expected to be infallible, but you are expected to pay attention and have a process in place. And if you don't do that, you have litigation liability, unfortunately. ERISA gives your employees the right to sue you for fiduciary breaches, and it gives the Secretary of Labor the right to sue you for fiduciary breaches. What does that mean? Obviously, that would be a great disruption to your business, but you are personally liable for the losses that are caused by those fiduciary breaches. So you have a lot of reasons to pay attention to this. Number one, you can save yourself money. Number two, you can have a better workforce that is happy because they're not, have a high quality healthcare plan, and you can avoid liability under ERISA. So it's a win-win situation.
Thank you. I think when you say you're personally liable, who's personally liable? The individual or the company, or both? The
individual. Now, the company may have an agreement in which they will pay for your liability, but you are personally liable. So say, for example, you work for an employer that goes out of business and you are the fiduciary. There are many, many cases in which fiduciaries, individuals, are required to pay money to the plan to make up for fiduciary losses. And that's just the law. It's happened in the pension space for years and years.
All right, well, that should get someone's attention, gets my attention, I'll tell you. Wow. Okay, thank you. Julie, so how does quality fit into the equation with the CAA?
So right now, all of the focus has been on cost, and that's what everyone has been talking about, because that really is sort of the first step. Is people don't even know, plans don't even know what they're paying for healthcare services. But once you get the gag clauses removed, that's not sort of the end. That's just the first step. Then you get the data and you have to use it, and you're supposed to review it and look at it and figure out, is what I'm paying, what we're paying for these services, are we getting reasonable value in exchange? As you go through that process, that's where quality starts to come in already. Because if you notice, for example, you might say, oh, wow, well, this hospital is very inexpensive. We should direct all of our, as many of our employees there as possible. But if that hospital has a high reinfection rate, a high infection rate while you're in the hospital, a high readmission rate, high malpractice rate, anything like that, then you have to look, is that a good value? You're paying for something, you're paying less, but people are going there more or need follow-up care. And it's not just sort of a financial issue, it's an ethical issue. Are we going to direct people to someplace that's, maybe below what is a reasonable standard of care in other hospitals? And that means if it's a hospital that's in the news all the time or has grades of D or F, when you look on all of these available resources that already exist, you really want to rethink, do you want this to be part of your network? And you have to, at a minimum, talk to your TPA or whoever's providing you with network access and say, why is this hospital included? And do we have to have it included? Or even stronger, we don't want to include it if you want to cut something out. And it might sound academic and something way down the road, but it isn't, because this can already sort of be an issue where employers face liability in the mental health parity area. So right now, this is sort of where most of the lawsuits that have been filed against employers and insurance companies exist, in the mental health parity space. And what that says is you cannot have a difference in quality or quantity of benefits on the substance use disorder and mental health side of a health plan than you do on the medical and surgical side. So this is a good example that already exists. Is there might, in most plans, the network adequacy on the mental health and substance use disorder side is really inadequate compared to the medical side. And if everyone who needs, for instance, inpatient, substance use disorder treatment is being sent to some sketchy place that you saw in 60 Minutes, or, is sort of like a wilderness therapy that keeps getting sued or something, you really need to rethink that and think, this is not the same as the other side, where if someone needed their appendix out, they could have their choice of, 1,000 facilities. But on this side, I have a choice of 2, and both of them are substandard. And a place where this comes up often is for people with children on their plan, covered dependents. It's very difficult to find child therapists in your network because there's just such a shortage. Now, I think telehealth has improved this quite a bit and is a really good sort of improvement. It's not the full solution, but as it is right now, it's just very difficult already to have the same quality on that side, and you're required to. And when you do your mental health non-quantitative treatment limitation, so that's not financial, that's about things like, are we being treated the same, are the same pre-authorization requirements, same step therapies required? That's where quality definitely already matters. And you have to look at it, because if they're not the same, and if there's some really terrible quality issue on the mental health and substance use disorder side, you could already face sort of legal action in that area or enforcement action. Another, sort of place where this comes into play is health equity, which is a very important and growing concept. And, recently in the news, I think we must have all seen it, there's a woman who's a professional athlete, and she died giving birth. And there's just no reason for this. In today's day and age, we have a terrible, maternal mortality rate. And I think, Leah, that Leapfrog's done a lot of work on this, and that you have to sort of bring this to the public's attention. And the fact is, it should be getting better, and it's not. But if you have a health plan, and if you're sending, your female employees to some terrible hospital where they have awful mortality, infant mortality rates or maternal mortality rates, that's something that you really need to not only be thinking about from a quality perspective, but from a health equity perspective, because if it's far more dangerous for your female employees to use your health plan than it is for your male employees, then you have other equity types of issues. And that's just one type. There's lots of types that you can have. So there's a lot of ways that this already comes into play now. And one more that I'd mention is, many employers and plan sponsors have switched to high deductible health plans over the past several years, which is understandable because of how costs have gone up. But that could undermine an attempt to sort of enhance the quality of your plan. And if you have a higher quality plan that some of your employees can't afford to use, not only is that a health equity issue, but it's an issue of, is it good quality if nobody can access it? If it just exists, but it's not usable, then it's really not hitting the quality button. So to sort of close the loop on this whole thing, people should think about the health plan. We should about the health of our employees the same way we think about the health of our 401k plans. So this is, everyone's used to that because it's been going on for about a decade. But in that space, everyone is aware, or fiduciaries are aware, that you're not just looking at the price you're paying for record keeping or what your investments are, but is it a good value? What are you getting in return for that? And that's really the key for your own healthcare and your employees' healthcare too, is not just what am I paying for this, but is it worth it? Am I getting a good outcome? If you start there, that's a sort of a really good starting point to increase quality while you're containing cost.
I'm glad you mentioned the issue of value, Julie. That's where I think that's where I come in from Leapfrog's perspective. We think of value in most industries as a combination of price and quality. So you want to get the best price and the best value, or the best quality for the best price, and that equals a good value. I think in healthcare, we've tended to talk about value, and really what we mean is cost. I mean, most of the time when they say it's a high value plan or something, it's a high value contract, that means it's the prices are good. I think that's mistaken. Now, obviously, I say that from the perspective of an organization that's focused on patient safety, but I will say that there is no good price for bad healthcare. And so most people, even when they talk about value in healthcare, there's almost an assumption, well, it's going to be, first we want great healthcare, and then let's talk about getting the right price for it. But I think there's sort of a built-in assumption that all healthcare is equally great, and that's unfortunately not the case. Healthcare is notorious for variation in the quality of care, and that variation can very significantly impact your risk of being harmed in the course of getting healthcare, or your opportunity for getting the outcome you're seeking when you go in for surgery, or for any other kind of treatment. It is extremely important for people to recognize the difference in the quality of care among different providers, whether they're individual providers such as physicians or hospitals or other kinds of facilities. So in the area of patient safety, I see that as a really front and center for consideration as a fiduciary, because patient safety is where patient safety is about, I'm going to use just a very blunt term for it. It's bad care. It's bad stuff you don't want to have happen. It's the infections, it's the errors, medical errors. So getting the wrong medication, getting the wrong, slipping and falling when that should have been prevented, getting a wound from a pressure ulcer that started as a regular, bed sore and turned into an excruciating wound. And all of those kinds of errors and accidents and infections can literally kill you, and it's the third leading cause of death in this country, are errors and accidents and injuries from these kinds of events. And what we know from tracking this at Leapfrog on behalf of purchasers, we were founded by purchasers, we have found that you have twice the risk of dying at a hospital that gets a poor grade from us as you do of a hospital that gets a good grade from us. And we do grade all hospitals. So it is very important from a fiduciary perspective that employers make sure their employees are aware of that. It seems to me that with the concept that both Karen and Julie, you have particularly educated me on around ERISA laws, that really its process is extremely important. And it seems to me that the process that employers can undertake is to inform your employees of what you know about the variation in quality. And what you know are things that, thanks to employers over 20 years, we have access to that information. But that is literally thanks to employers for pushing the envelope for 20 years to try to get more transparency so that we actually can inform employees. The fact that Leapfrog can issue letter grades on the safety of different hospitals is entirely due to advocacy by employers who have literally for 20 years have pushed to try to get more information about these errors and accidents, bad things happening in hospitals, so that we can we can have something like a letter grade, and there are lots of other tools. That's just one, it's for free. But there's plenty of others that we talk about in the white paper that are available to employers and available to the public that people can use to understand the difference among these places, whether it's for patient safety or just getting the right outcome. So those are the bad things. And that to me is like first and foremost, you start with that. And then the second thing is where they can get the best care. But the exposure on value, on making sure employees get value, begins to, in my perspective, begins with quality. It doesn't begin with pricing. It begins with quality, because nobody wants it if it's not good. They don't want it. I don't care how much you charge for it. It isn't a good value if it's bad. And so it's very important to be able to recognize those things. And I think that the white paper really spells that out. But I think most importantly, there are opportunities employers have to inform employees. And now that they have access to their own claims data, there's opportunities they have to go through and look at those and look at their own claims and look at their own experience. And there are more resources they have at their fingertips to be able to at least start the process of helping employees get the right care. And so I see Karen has a comment.
Yeah, I think that one of the things that gets confusing is that employers only have a set amount of money to pay for healthcare. And so I don't think we're saying that you must go out and buy the most expensive healthcare. I think what we're saying is with your limited dollars, you must make sure that the healthcare that you're getting is the best you can get. And I think that one thing that people should be aware of is that the cost doesn't necessarily correlate with the quality. And so part of what you have to do is you have to think, these are my limited dollars. What is out there and available? What is the best quality I can get for those limited dollars? And maybe I have to think about a different way of providing healthcare. There are those options, but I think that ERISA does recognize that this is a voluntary system, and that there are limitations to resources that employers have to pay for healthcare.
No, that's a very important point. Thank you, Karen. Yeah. So I want to clarify. I'm not an advocate of spending all the money that you can possibly spend on healthcare. We need to spend less, but typically, not always, but typically, the higher the quality, you can lower costs that way, but not always. So please don't get me wrong. And we do talk a little bit in the paper about how certainly improving patient safety will improve costs, because it's just obvious if you get an infection and you're in the hospital for a month, that costs more than if you didn't get an infection and you just were there for 2 days. So, but it is a very important point. We have a bunch of questions. So let me start with, despite the regulations, we have a large TPA declining to provide all the requested data until pending challenges to the CAA requirement are adjudicated. Oh, so Julie, maybe you want to comment. It looks like you're the commenter on this one.
So that is an egregiously unacceptable response. There shouldn't need to be a wait for the outcome of litigation, since the law already requires very clearly that gag clauses be removed and employers or fiduciaries be given access to claims data on a per claim basis with every bit of encounter information that the TPA has in their possession. So that is an absolutely wildly unacceptable response. We are actually, Karen and I have one of the cases that are challenging a refusal to provide information and using gag clauses still. And having to bring legislation, you shouldn't have to bring legislation when the law is pretty clear the way it is. But because of this type of attitude, there is now litigation that just made it out of a House committee this past week. And the good news is it's bipartisan. It came out of committee with overwhelming yays and I think 1 or 0 nays. And there's 4 different bills, all to shore up some of these perceived loopholes or gaps in the existing legislation. And one of them relates to sort of the gag clause removal and what that will entail. And it and it would, if it passes as currently written, it would add a penalty to the service provider for non-compliance. But the idea that any carrier or TPA would take the position that they're going to wait and see how this shakes out in the face of, you know, there's DOL guidance already telling you exactly what you need to do. There's a letter that we circulated online that's widely available from Congress that's sort of about compensation disclosures and how all of these provisions are supposed to apply to TPAs. And plans already had the right to get their claims data. This is, as Karen was saying, these are duties that already existed. Up until the CAA passed, there was sort of unfair provisions being used to block what fiduciaries need to do. But there's always been an acknowledgement in the law that if a fiduciary needs information to do their job, that the service provider that holds that information has an obligation to provide it to them. And not doing so prevents the fiduciaries, causing the fiduciary to not be able to do what they're required to do and to really breach their duties if you know, putting it to that. So whether or not the TPA will be found to be a fiduciary or not, you know, we would argue that if a TPA is withholding information and they're the only one that has it, then they're definitely a fiduciary. Many courts would agree with that. Some don't. You all must have seen sort of the mass laborers case where in the First Circuit is not a great circuit to argue that your TPA is a fiduciary. However, you're more likely to be found as a fiduciary, as a service provider, if you're sort of acting willfully, if it's not just errors that you're making, but you're withholding information and acting as if you're in control of the plan, because that's what that is. If you're the only one with the information, then you're the only one who has control of administering this plan. So I don't think that's an acceptable response. And I would urge whoever's being told that to push back or have their ERISA counsel push back, request a call with their TPA's in-house counsel, because that's a really unacceptable response.
And I would just add that as fiduciaries, you're going to have to attest by the end of this year that you've removed all of your gag clauses. So what happens when you recognize that you can't get access to your data because there are gag clauses? How are you going to handle that attestation? So very important, as Julie said, to get a hold of a good ERISA attorney or your ERISA counsel to get on the phone with them and require them, you know, force them to come forward with the information that's required.
Right, because for this employer that asked the question, if they can't attest to the fact that the gag clause is removed, then the challenge that could come would be a challenge against them, right? They're the fiduciary. Even if their TPA is saying we're going to wait to adjudicate it, the adjudication would be against the employer.
That's right.
That's even more egregious. Okay, get your ERISA attorney.
And don't attest to it. If you can't get your data, don't attest that your gag clauses have been
right. Oh my God. Okay. How can employers work with their TPA to improve the access to care to meet the mental health parity? That's a tough one. Anyone want to try that one, Jamie? Worked on it.
That really is a tough one. I think there are some areas of the country that don't have access to the same types of facilities that other areas do. And I think the best thing you can do is to, again, go back to that fiduciary process that Karen spoke about, is to provide an exclusive benefit at a reasonable price. And the best way to do that is to work with your valued partners to determine how do we get access to these types of quality providers at a reasonable price. And sometimes you have to think outside the box. Maybe it's not that somebody's going to a place that's local right down the street. Maybe it is telemedicine or other options, but you have to show that you had a prudent process in place to deem that what you were doing under facts and circumstances were in the best interest of your participants, regardless of the challenges associated with it. But that's a great question.
And just to follow up sort of the practical, what can you do right now in actuality is, you know, hire a professional to do your NQTL comparative analysis. and make sure that one of the, so this is why gag clause removal is so important. You cannot do this report if you don't have your data, because you need this information to compare it. So for instance, if you don't know readmission rate on each side, then you really can't make a proper comparison, which is why we keep saying the gag clause is the key to everything else. You really have to get the data. Once you do, I would say the first step is hiring a professional to look at the data, do the comparative analysis, and figure out where the weak spots are. Then you said the first step would be to set up a call with your TPA. Ask, do you have your own parity analysis that we could look at that would show why there's parity here? Because here's what our analysis shows. And, you know, so from a fiduciary protection standpoint, you want to show that you not only did what you're required to do and did the analysis, but that you tried to make it right once you did that. And whether or not you'll be successful in doing that is, we're still, you know, to be honest, it's unlikely you will be able to right now. But that doesn't mean you won't. You can do an RFP, you can threaten to leave, and especially the bigger you are, the more power that has. And in the RFP, that's where you have the most power. You can put in the things that you require if you're going to bid on this. So you say, we have to have this. We need to see your comparative analysis up front if you want to bid on this. Things like that to sort of make sure you know what you're getting into before you're in. And, you know, I just see that I think that you can't, so doing the analysis is the first step, and then trying to partner with your TPA is the great next step. Some TPAs, especially independent TPAs, will try and remedy these things if you point them out, or they'll at least work with you and allow you to do whatever you can to make it better. It's harder usually to work with a carrier TPA, although, you know, depending on what you want to do, if you have creative solutions, they are open to it on occasion too. So it's really just trying new things. And that is a huge key in this area, is no one tries anything anymore because everyone's just sort of used to, you know, no. And there's this feeling of the beatings will continue until morale improves and nobody even asks anymore. And yet if you don't ask, you don't get. And so you have to try and give creative solutions. So you can look at a resource like Leapfrog or other resources out there and say, hey, can't our plan incorporate, you know, services from this hospital into it, because that would, in our opinion, bring parity in line. And we want them to be in network, things like that. Just you come up with your own solutions and propose them.
I think the CAA, if nothing else, does give an incentive and a reward for employers that are trying new things. I mean, making the effort. I think that if I had to think of a bottom line of what it means for employers, that's got to be the number one. Try things.
Process, as Karen said.
Okay, we have another question. We have many questions. Please enter your questions in the chat. We have a Q&A button, and we are transferring the questions over there, but try to do it in the chat, please. Okay, and I'm going to start the answer on this one, and then I'll turn it to my colleagues. How does a plan deal with trying to use lower cost facilities such as ASCs, ambulatory surgery centers, when quality data available from the ASCs just isn't available to compare to hospital data? It is not available. That's why actually Leapfrog started a program. We are actually rating ASCs. We have about 100 ASCs plus outpatient surgeries in our rating system. So you can go on Leapfrog Group and look up hospitals and look up their outpatient surgeries as well as look up ASCs. But it is a slow process, and CMS does not have as many requirements for ASCs to report. So we don't have as much mandatory data on ASCs, even though, or outpatient surgery, by the way, outpatient hospital surgery, even though more than 60%, some say 70% of surgeries are now done in these settings. Increasingly more acute surgeries, such as hip replacement, shocks me, but those are done quite a bit now in the community in ASCs or in outpatient hospital units. So we have started, we need employers to get more ASCs to report that data voluntarily. That's how we get it. Employers, when they ask, tend to have a lot of influence. It is important, and there is data you cannot get from claims that's important, like infection rates, visits to the emergency room subsequent to a surgery at an ASC, for instance, are the kinds of data that's not always easy to get from your own claims or for claims in general. So we do need more reporting. We also have some information in the white paper about vendors who are bringing claims from vast claims databases together and offering insights. So I encourage you to look at that as well. And again, to work with us and others to advocate here in Washington for better access to some of that data. Does anyone want to add something to that?
I think he gave a pretty good answer.
Okay, thanks. Okay, another question. How does use of AFPs impact quality, especially when certain medications and benefits are carved out? Any insights on that?
AFP, I'm sorry, there's so many abbreviations. What is AFP?
You know
short?
what? I actually don't know what it is. Does anyone know what AFP is?
They
Okay,
mean RFP?
No.
okay, so the person who asked the question, can you try to check? Can you let us know and we'll come back to you? Okay, how do you determine if you are getting value for your dollar? There's a good question. A question for the agent,
Benchmark.
really.
I was just thinking you would jump in with that.
Yeah, I mean, so you have to benchmark your covered service providers, and benchmarking is not just about fees. And I think this is one of the reasons that the disclosures now are required. So you're getting direct and indirect compensation for the services that are being provided. So the first thing you have to understand is, are you actually receiving a service for the fees that are being charged? Can you tie that together? And then what are the outcomes of those services that you're receiving? So you have to monitor it. You have to start with a baseline and you have to review it on an annual basis. But it comes down to benchmarking. You know, what are you getting for the dollar that you're spending? What is the benefit you're actually providing? And that comes down to benchmarking, monitoring, reevaluating, and continuing to determine, are you moving the needle? Is the program you have in place actually doing anything? And that's really important to them.
Well, I'm not an attorney, but let me add from my perspective, having probably knowing more than I should. I'm probably know enough to be dangerous, put it that way. But thanks to you all, the three of you, and you have taught me quite a bit about ERISA law. So let me just say one thing about that, about that your exposure as an employer around ERISA is going to come if you don't make an effort to inform your employees about what you know about the quality and safety of various providers that they choose. Because, you know, what's high value to me might be low value to you. I mean, I'm looking for I think that that if I go to a hospital, it should have a really nice lobby. Maybe that's me, I think, and then good parking. Maybe that's really what I think is good. And I expect to pay this much for it, you know, whatever. I might have a price point in my head, and that's value to me. I should at least be able to have information. If the employer can get it, I should have access to it. And an employer should encourage me to say, you know, you really should look at infection rates at different hospitals you're choosing, because they really are different and it's a big deal. They should inform me. It seems to me that from the point of view of ERISA or fiduciary responsibility, that you as an employer to protect yourself would be as transparent as possible. It's really the starting point of that process of improving quality for your employees. Would you agree with that, Julie? Is that how I interpreted?
Absolutely, yes.
Okay. I don't have to go to law school.
Yeah, no, you play a good lawyer on webinar. You're already set.
Thank you.
I think that I do think that you, you know, if you don't, it's really an indicator that you've had a process in place. So you really are saving yourself from inquiry by participants who are unhappy. And I do think that it's important. And there is a duty under ERISA to disclose information to people, to your participants, information they need to know. And one could say that's information they need to know.
Okay. Go ahead, Julie.
So I just wanted to follow up on the prior question about the AFPs, so it didn't get lost, because I saw the person typed in that it's alternative
Oh,
funding
okay.
programs. And I just think that's a really good question, because that's like advanced quality and cost considerations. That's sort of way above almost where we're at right now, but that's an extremely complicated issue. And so with all things for an ERISA plan, you want to look at it holistically. What's the entire, look at the whole plan, and is it worth it? Is it worth carving out maybe, 1 or 2% of these high dollar claims if it's going to cause massive disruption to the plan, if it's going to make the members that are subject to it extremely unhappy? You have to really sort of look at all the pros and cons to it. That being said, reality is that the high cost drugs are a terrible burden on plans, and it can be just a few drugs that account for 50% of your PBM spend at any point in time.
Right.
So to the extent there are alternatives available, at a minimum, the fiduciary process that you put in place should include considering that. Can we carve out specialty drugs? Is there a way to do that? Is there a way to, help this member opt out entirely and order their own 90-day supplies from Canada, which the FDA has an exception for this, in certain circumstances? Is there a way that there is financial assistance available? Because, my stepmother had a stem cell transplant and she was on some drug afterwards that was like $75,000 a pill. And, I don't care how much money you have, unless you're a billionaire, that is extraordinarily prohibitively expensive for anybody. So it depends. Every single situation like that, though, is going to be fact intensive. You have to look at what the alternatives are, look at the facts of sort of what your plan, what's happening, what the solutions offered could do for you, and what disruption and possible downside could come with it. So I know that's not the best answer, but that's where you start, is sort of gather all the information you have and then put it through your process that you've set up. Is this good? Could it be helpful? Will it decrease employee satisfaction, make life more difficult for them? Will it make the health plan less valuable or lower quality for them? Or is there a way to increase value while you're lowering costs, and find a specialty drug program that you can work with that will not have a huge disruption and will reduce costs for you?
For some of the specialty drugs, and some of the spend that I've heard from employers, it can actually significantly increase the health costs for all employees by, sort of being, quote, unlucky with having very small numbers of employees who need certain medication. So is there any argument that would ever be defensible, I guess, in court, that an employer felt that this was too prohibitively expensive, that it would impact, that as a fiduciary for all the employees, it was going to impact their costs, and that was therefore not prudent, and they had to monitor the spend as a result of that?
I would say they actually have a duty to figure that out, because their duty is to all plan participants and beneficiaries. And, so unfortunately, this is a hard job for plan fiduciaries, without a lot of guideposts out there, and they have to make hard decisions. But nobody expects you to provide everything that every employee wants. It'd be nice if you could do it, but you do have to balance the overall cost in maintaining a plan and the expense to everybody in providing certain things. That's where expertise comes in. I would be talking to an expert about it.
Well, that's interesting, because so you're not a fiduciary for every individual employee or every individual covered life. You're a fiduciary for the group. Like that's, I realize that's a subtle distinction, but it's not actually, if you think about it from the point of view of the case of a certain particular specialty drug spend. That's where it gets very tricky.
Yeah, and I think that you see it in the pension space, where you had to make decisions about everybody. You can't just make decisions about that's going to benefit one person to the detriment of everyone else.
Thanks. Okay, so we have a clarification. Well, it's a correction around the issue of the athlete who died from a pregnancy-related complication. So I do understand the writer says that they died from pregnancy-related complications that can occur at any time. they didn't die in labor, and it was not caused by the providers. There was no report of calling 911. So I understand that point. That's true. She was sadly, she was not in a setting where she was safe during this incident. However, I will say that we are the only industrialized, we're the only country, actually, the only industrialized country that is seeing an increase in maternal mortality. Every other country has reduced it over time. You would think we could reduce that one factor more than any other, that maternal mortality would be going down. It is going up in this country. And Black women are 3 times more likely to die in childbirth or related complications than other women. So it is a major issue of health equity and a major issue in general in our country. It's one that we should be able to solve. It is shocking to me. We have many advances in maternity care that have happened over the past 100 years, and yet here we are with these horrible tragedies happening. So we know we can solve this, and we're going to solve it. This is about fundamental practices that are happening, that have to happen consistently in maternity care, that are not always happening consistently in maternity care, and we have to get better at it. And it's an outrage that we are where we are. It just is an outrage, and there's no other way to put it. But that said, I think the example, the questioner is correct to point that is maybe, that's not an example that is the cause. It wasn't caused by providers.
And mea culpa, she was in labor, but she was at home. I agree that we don't know what caused it. And it wasn't a great example to use. So, I retract. It was just a good example in my mind because it was just in the news. And I was thinking, oh my goodness, an Olympic athlete dying in childbirth is insane. But you're right. We don't know yet what happened. And so it's not a good
know
example.
that particular case, whether that was caused by providers, likely not had anything to do with the providers, but it was still a death related to maternity care or related to childbirth. So so it is relevant to at least consider that in this overall statistics around maternal mortality. Okay, do health insurance companies have a fiduciary responsibility to their fully insured subscribers under some law other than ERISA? Or ERISA? Who wants to take that? Julie?
Sure. So I think that is the question. I'm not sure if it's about the employer or about the actual health carrier. So a carrier does owe obligations under a fully insured plan and under self-insured plans. They're just different. But under a fully insured plan, even though the carrier owes, they have to follow the terms of the policy. You can sue them if they don't, follow the terms of the policy, if they deny coverage improperly. Unfortunately, it doesn't change your liability as an employer under ERISA. Now, one of the areas in the CAA where I think fully insured plans have a bit of a problem is in the mental health parity analysis in that provision, because it sort of tells fully insured plans you can rely on your carrier and you can rely on what they say. But I can tell you that, first of all, the carrier likely doesn't have a report that they can cough up to you if you ask for it. And the same law makes that a plan document and says, if you get a request as the employer for a 104B request, it's called, for plan documents, and what they want is the report, you have to provide it. And if you don't, the penalties are, in addition to the IRS excise tax of, $100 a day per affected participant, there's the current rate for a 502B violation, which I think is like $100 for not producing plan documents, rather, which I believe is, $176 a day or something like that per participant, per affected member. So that can add up really quickly. And if you've relied on a carrier and then you cannot get a copy of this report, that is a sort of one of the problematic areas, in my opinion, of where that law isn't written to 100% make it work right. But yeah, there are. So if you're in a fully insured plan, the carrier does have obligations, mainly contractual ones, sometimes also heightened sort of consumer obligations and things like that, but it doesn't absolve the employer of any of their ERISA obligations, or if it's a non-ERISA plan, of any of their other obligations at law.
Or if they have networks requiring people to go to certain doctors, I don't see why it's any different than if you're self-funded. You just have to figure out whether that's a policy you want to buy and whether it's valuable.
Okay, we have like 2 minutes, so I want to just get to one more question, and then what we'll do is we'll send the questions to the panelists, and we'll post your responses. If you want to, any of the panelists have responses they'd like to add to this, we can then post that alongside the white paper on quality in CAA and the recording of this webinar. So the one question, do things like the quality comparisons you're talking about apply to insured plans as well as self-funded plans? Jamie?
So the CAA does apply to both fully insured and self-insured, and so does the quality piece of it, because as a fiduciary, you have an obligation to determine if you're providing an exclusive benefit at a reasonable price, which is part of quality. So it doesn't matter what size or what type, you are as a fiduciary responsible for that.
Okay, that's new, right? I don't know if self-insured have always had that level of fiduciary responsibility.
Any ERISA-based health and welfare plan, and Karen and Julie can correct me if I'm wrong, have always been under ERISA. It's just that they haven't been able to really fully do their fiduciary duties because they've lacked data. And really that's what the CAA has done, is to add that layer of transparency to provide them with the information so they can provide that fiduciary process.
And that's what it's supposed to provide, for sure. I think a lot of the comments reflect that it's still not working at full efficiency, but we're getting, we're ramping up to the place where employers can sort of do a better job of judging quality and cost. And, as Karen, at the very beginning, she pointed out that more than 20 years ago, the DOL said that if you are running an ERISA covered plan, that quality is one of the most important aspects when you're choosing a service provider, and that counts if it's a self-funded plan or fully insured. That's your service provider. And if you buy, some sort of plan that is awful or limited in some way, then yeah, you could be accountable for that if you don't take that into consideration. And there's no record of a fiduciary process that you went through about why you selected that, despite its warts or things like that. So it's much more difficult to affect change in a fully insured plan. And so that is sort of a consideration in the future, is you're sort of, that's the sort of place where you might want to try and enter into agreements where, the carrier agrees to take on fiduciary liability for certain things. If they won't change things that you ask for, these are the things that plans have to start doing, and say, well, are you going to be a fiduciary then? Because right now you're going to say, you're going to put in our SPD that you're doing only ministerial duties, but we're asking you to do something and you're the one directing this. So that's not true. And if you won't let us make this change, then you should take on fiduciary responsibility for the changes you're refusing to make.
All right, well, unfortunately, we're out of time, but I think that was a good place to end, Julie, because it really is a reinforcement for employers that is what the CAA was meant to do, is reinforce you and give you the tools you need to be a good fiduciary, to have the level of transparency that you absolutely need and that your employees need and you all deserve. So we are going to continue to push for it. And that is really why the CAA, the parts of the CAA anyway that we're talking about today, came from a lot of employer advocates. So even though it's a little difficult, to say the least, to implement this right away, fundamentally this will help and strengthen employers in their management of excellent quality and cost-effective health benefits for their employees. So I want to thank everyone, Karen Handorf, Julie Selesnik, and Jamie Greenlee for being part of this. And go on our website, or you should also, if you're registered, get a copy of this webinar as well as the white paper, which is out officially tomorrow. But if you are on this webinar and registered, you get to get an early copy of the CAA and healthcare quality, our new white paper published by Leapfrog and co-authored by everyone you've heard from today. And there's also a toolkit and lots of resources on the CAA that's available for download for free from Leapfrog. And I want to thank again, thanks to everyone.
Thanks for having us.
Thank you.
Thanks for having me.